Protest challenging agency's decision not to consider firm's proposal is denied where the proposal failed to comply with the solicitation's instructions, and the solicitation permitted the agency to deem non-compliant proposals ineligible for award. QED Systems, LLC, a small business of Aberdeen, Maryland, protests the issuance of a task order to Envision Innovative Solutions Incorporated, a small business of Manasquan, New Jersey, under a task order request for proposals, RFP, issued by the Department of the Army, Army Materiel Command, for engineering and technical support services. The protester challenges the agency's decision that the firm's final revised proposal was incomplete and, thus, unevaluable and ineligible for award. We deny the protest. On May 19, 2020, the agency issued the RFP, using Federal Acquisition Regulation, FAR, Subpart 16.5 procedures, to small business holders of the agency's responsive strategic sourcing for services indefinite delivery, indefinite quantity, IDIQ, contracts. The agency sought proposals for the provision of engineering and technical services to support the Army's command, control, communications, computers, combat systems, intelligence, surveillance, and reconnaissance center. The solicitation contemplated issuance of a single task order with fixed price and cost plus fixed fee contract line item numbers, a 30-day transition-in period, an 11-month base period, and 3 one-year option periods. As relevant here, the solicitation permitted subcontractors to submit their cost proposals directly to the agency, rather than to the prime contractor for inclusion in the prime's proposal, if the subcontractor deemed its proposal contains proprietary data. Section L of the solicitation, Instructions to Offerers, required cost proposals submitted by either a prime or subcontractor to include 3 parts: 1. A cost narrative, 2. A cost proposal, and 3. A sanitized cost proposal, which was to be the same as the cost proposal, but with all costs prices deleted. The solicitation provided for use of a best value trade-off award methodology, in which the agency would compare the technical volumes of the proposals to their cost price volumes to select the best suited offeror. The technical volume was significantly more important than the cost price volume. Additionally, the solicitation established that offerers must be determined eligible for award, and that the agency would evaluate proposals for compliance with submission requirements. In order to be considered eligible for award, the solicitation required an offeror to follow all instructions in this RFP, and provide all submission requirements for all volumes, among other requirements. The solicitation cautioned that failure by the offeror, or its subcontractor to submit the required information or documentation in the format, including formatting and formula requirements of the Volume 2 cost price, specified may render the offeror's proposal unevaluatable, and the proposal will be ineligible for award without further consideration. Further, the agency reserved the right to not fully evaluate the Volume 2 cost price of any offeror whose proposal failed to follow all instructions in this RFP, or failed to provide all submission requirements for all volumes. The solicitation established that the agency intended to make award based on the initial proposal submissions without conducting interchanges, but reserved the right to conduct interchanges. If interchanges were conducted, proposal revisions were to be requested simultaneously at the time interchanges were opened, and the solicitation cautioned that no subsequent final proposal revisions will be requested after the interchanges are closed. The agency further reserved the right to conduct additional interchanges with only the offeror determined to be the best suited, apparent successful offeror. The agency received 8 timely submitted proposals and, after conducting evaluations, selected QED's offer for award on September 30, 2020. Envision and a second unsuccessful offeror filed protests with our office challenging the September award decision. In response, the agency advised our office that it intended to take corrective action by re-evaluating and making a new selection decision, resulting in our dismissal of the protests as academic. Subsequent to our dismissal of its protest, Envision challenged the scope of the agency's proposed corrective action. In response, the agency advised our office of its intent to take corrective action again, which included, among other things, reassessing proposals for compliance with the solicitation submission requirements and, if needed, engaging in interchanges with offerers. In implementing its corrective action, the agency first re-evaluated proposals for compliance with the submission requirements. As part of that review, the agency determined that there were no offers eligible for award due to compliance failures. The agency then sent interchange letters to all 8 offers identifying the non-compliance issues in their initial proposals. The interchange letters advised offers that revised proposals would be considered a permanent part of the offeror's proposal, superseding prior submissions. The letter further cautioned offers that no subsequent final proposal revisions will be requested after the interchanges are closed. Finally, the letters provided that once the agency determined an apparent successful offeror, it reserved the right to engage in additional interchanges with only that offeror in order to finalize a task order. In response to interchange letters, the agency received 8 revised proposals, which it again reviewed first for a compliance screening. The agency found 5 of the revised proposals, including QEDs, to be non-compliant with the solicitation submission requirements. In accordance with the solicitation, the agency concluded that the 5 non-compliant proposals were ineligible for award and did not evaluate them further. Specific to QED, the agency found that one of the firm's subcontractors submitted a revised sanitized cost proposal in which it did not delete the cost dollar value from the summary of cost elements and labor tabs. The agency concluded that the subcontractor's failure to comply with the solicitation's instructions rendered QED's proposal unevaluable and ineligible for award without further consideration. In support of this conclusion, the agency explained that without this required documentation proposed in the mandated format, the agency could not fully evaluate volume I technical because the fully sanitized cost proposal was meant to be used by the technical evaluation team to assess the consistency of the proposed approach, specific to labor mix, between volume I technical and volume 2 cost price, without introducing any cost price based influence into the technical evaluation. After eliminating from further consideration for award 5 of the 8 proposals, due to failure to comply with the solicitation submission requirements, the agency conducted technical and cost price evaluations of the 3 remaining proposals. Based on evaluations and a comparison of the 3 proposals, the contracting officer, who is also the source selection official, selected Envision's proposal as offering the best value to the agency. Following notice of award and receipt of a debriefing, QED filed this protest with our office. QED maintains it was unreasonable for the agency to exclude the firm from the competition. QED contends that the agency had all the information necessary to evaluate the firm's proposal without the subcontractor's incompletely sanitized cost submission, and that the solicitation permitted the agency to continue with evaluation of the firm's proposal. Further, QED asserts that the agency should have corrected the sanitization issue through clarifications, and that by not doing so the agency acted unreasonably. QED raises additional ancillary protest arguments which we do not discuss. We have considered all of the protest arguments, however, and conclude that none provides a basis to sustain the protest. Completeness of proposal. We note at the outset that the protester does not dispute that one of QED's subcontractor cost submittals included in the firm's revised proposal was not fully sanitized. Nonetheless, QED maintains that the solicitation did not require elimination of a non-compliant proposal, but said only that the agency may eliminate such a proposal. Thus, QED argues, prior to eliminating the firm's non-compliant proposal, the agency should have assessed whether it could still evaluate the firm's proposal. Here, QED contends, the agency could still evaluate either by looking to the prime contractor's submission for the information missing from the subcontractor's submission, or by substituting the subcontractor's initial fully sanitized cost proposal submission for its non-compliant revised proposal submission. The agency responds generally that its review of QED's proposal was both consistent with the terms of the solicitation and reasonable. We agree. In reviewing protests challenge an agency's evaluation of proposals in a task order competition, our office does not re-evaluate proposals, but examines the record to determine if the agency's judgment was reasonable and in accord with the stated evaluation criteria and applicable procurement laws and regulations. As set forth above, the solicitation here required submission of sanitized cost proposals from both prime and subcontractors, and cautioned multiple times that failure to comply with all of the submission requirements may result in the proposal being deemed unevaluable and eliminated from consideration for award. Moreover, the interchange letter received by QED reiterated that failure to comply with the solicitation submission requirements may render an offeror's proposal unable to be evaluated, and required QED's revised proposal to be submitted in accordance with the requirements of the RFP. The interchange letter further advised that any revised proposal submissions would supersede QED's prior submissions. Thus, the solicitation permitted the agency to reject a non-compliant proposal. The protester acknowledges that the solicitation permitted the agency to reject non-compliant proposals, but argues that, prior to rejecting QED's proposal, despite the subcontractor's sanitization issues, it was incumbent upon the agency to determine whether QED's proposal could nevertheless be evaluated. The solicitation at issue here, however, did not include a requirement for the agency to make such an assessment before exercising its discretion to reject a non-compliant proposal. Accordingly, the pertinent question is whether the protester's proposal complied with the solicitation submission requirements. The record reflects, and the protester does not dispute, that one of QED's subcontractors submitted a cost proposal that was not properly sanitized in contravention of the solicitation's requirements. Thus, in accordance with the solicitation's clear and express provisions, the agency reasonably eliminated QED's revised proposal from further consideration for award. Clarifications. Similar to the protester's contention that, even though the solicitation permitted the agency to eliminate non-compliant proposals, the agency should have exercised its discretion to not do so, the protester also argues that the agency should have engaged in clarifications with QED to permit the firm to fix its non-compliant proposal. In response, the agency first notes that the procurement at issue here was conducted using the fair opportunity procedures of FAR Subpart 16.5, not the negotiated procurement procedures of FAR Part 15. The agency further points out that even in a FAR Part 15 procurement, an agency is permitted, but not required, to engage in clarifications. This procurement was conducted as a competition between IDIQ contract holders and, as such, was subject to the provisions of Section 16.505 of the FAR, which does not establish specific requirements for conducting clarifications or discussions. When, as here, an agency conducts a task order competition, as a negotiated procurement, however, our analysis regarding fairness will, in large part, reflect the standards applicable to negotiated procurements. As noted by the agency and acknowledged by the protester, the FAR provides agencies with broad discretion as to whether to seek clarifications from offerors, and even in a FAR Part 15 procurement, offerors have no automatic right to clarifications regarding their proposals. Rather, agencies may, but are not required to, engage in clarifications. Here, the agency engaged in interchanges with QED to allow it to revise its non-compliant and ineligible initial proposal, and advised that no subsequent final proposal revisions will be requested after the interchanges are closed. In its revised proposal submission, one of QED's subcontractors introduced a new error that resulted in the firm's revised proposal reasonably being found non-compliant and ineligible for award. Despite QED's protestations to the contrary, the agency was not obligated to reopen interchanges with QED to permit it to correct its subcontractor's mistake. In any event, even if we were to agree that the agency was required to engage in clarifications with QED, which we do not given the nature of the error could not have been addressed through clarifications. Recognizing that this procurement was conducted under the less stringent requirements of FAR Subpart 16.5, we are informed by FAR Part 15's description of the spectrum of exchanges that may take place between a contracting agency and an offeror. Clarifications are limited exchanges between the agency and offerors that may occur when contract award without discussions is contemplated. An agency may, but is not required to, engage in clarifications that give offerors an opportunity to clarify certain aspects of proposals, or to resolve minor or clerical errors. Section 15.306(b)(2) of the FAR specifically provides that exchanges under this section shall not be used to cure proposal deficiencies or material omissions, materially alter the technical or cost elements of the proposal, and or otherwise revise the proposal. Here, to become able to be evaluated and eligible for award, QED's proposal would have required the submission of a properly sanitized version of its subcontractor's cost proposal. Providing an offeror the opportunity to revise its proposal and cure a deficiency would constitute discussions, or interchanges as the agency calls it here, not clarifications, because that would require the revision of information that was a condition precedent to being eligible for award. Thus, while the protester views its error to be minor or clerical, correction of the error could not have been accomplished through clarifications, as contemplated under the FAR. Therefore, QED's contention that the agency was essentially obligated to engage in clarifications regarding the firm's non-compliant cost proposal, and to permit the protester to submit revised information, lacks merit. The protest is denied.